Welcome to panel number 2. We are going to talk about litigation leadership, which dovetails nicely with the panel we just heard. I was sitting next to Phil, and he's like, well, I hope they don't steal our thunder. And it turns out y'all didn't. You talked about a lot of things, touched a little bit on litigation leadership, but I think we have plenty to say. During the prep call, I took notes, and it's just like I'm all over the board because they had so many great ideas. So I'm hoping they will remember most of those and share them with you. So this is a hot topic, although it's also an old topic, but it's a hot topic. In fact, yesterday, multiple people, including Julie, sent an article to me that was published in IAM yesterday, where the previous patent policy person from Amazon was talking about how litigation is moving away from the United States into other jurisdictions and how that's detrimental to our innovative system. So with that, I'm going to start by throwing out to the panel the first question, and I'm going to kind of let them free-form it. I have a few other questions, but I'd much rather hear from them than myself. So just to set the stage, the litigation landscape seems to have changed over the last decade or so, including where cases are being brought. So these changes have occurred within the United States. There's fewer cases being brought in Delaware after Judge Connolly's standing order requiring disclosure of funders. Different cases are now being brought in the ITC due to injunction concerns, but especially after Lashify made jurisdiction there possibly easier. But more relevant to this panel, more cases are being brought in various venues around the globe at rates higher than before. And so to the first question out to the panelists is, either in your observations or practices, what changes have you seen? Where are patent infringement cases being brought? And why are patent owners choosing these venues rather than the United States? So very broad. We could spend the whole hour on that, and we just might. So I'll let whoever start that wants to go for it.
I'm happy to get us started, I guess. So I should disclose I'm an economist, so I like to bring some data to the conversation. And I've been informally tracking multimedia patent litigation. It's a growing area of litigation, particularly involving standard essential patents. And if you look at, and this is really just based on public reporting of cases, so this is not like any serious data collection, but if you look at the public reporting of cases in this specific area, the top 3 litigation venues last year were the UPC, Brazil, and Germany. The next most popular venue was U.S. District Court. And interestingly, despite Kristen's introduction, the least popular venue was the ITC. And so because these multimedia cases often involve SEPs, it's, I think, well understood that it's pretty difficult to obtain injunctive relief, including exclusion orders at the ITC. For U.S. patents generally, right, but certainly for SEPs specifically. And so I think what we're seeing in these trends are parties turning to venues where injunctive relief is more readily available, because this is really the main tool that they have to bring recalcitrant infringers to the negotiating table. So maybe I'll stop there, have others chime in.
Julie, can I ask a question, if that's okay? You didn't mention China, but my understanding is that China, blows the rest of the world away in all categories of IP litigation because of the just number of small disputes there. Can you comment on China, or did you not have data for them?
This was focused on this specific sort of subset of litigation, so just looking at multimedia cases. I'm not really sure why China in that case is not a big venue. I think we're certainly seeing China become an important venue for implementers of patented technologies as a place to get global rates set, particularly in the SEP space. So that's one of the 2 jurisdictions, the UK being the other, where you can get a global rate set without the consent of both of the parties. So China certainly has become popular for that reason. mostly, I think, among implementers. Haven't seen it in the multimedia space as much, though, but that might not be representative of patent litigation more broadly.
I'll give you a guess, Steve. I think that for multimedia, can you guys hear me? I think some of the big streamers that have big markets in the jurisdictions that Julie called out do not exist in China. And so it's just like a practical market concern is my best guess. The other is that while China's becoming a little bit more active, it's still perceived as if you're a Chinese company or an SEO, then you're really immune. So if China has its own streamers, it doesn't make sense. But more broadly, just to kind of right on top of Julie, I think actually standard essential or not, you need predictability. You need predictability in how long a case will go, how much it will cost, and what the remedy is that's available to you. And all of those are stronger in Germany, in the UPC, in Brazil, and in the right cases in China.
Yeah, and I would just echo, it's not just the standard essential patents. If you have a patent dispute that is international in reach, and if the defendant has business in some of these other jurisdictions where you can get injunctive relief, that could be a major pressure point that could lead to a settlement. As they say, justice delayed is justice denied. So you have to look at how long could it take to get a final judgment and for that to be held up on appeal wherever you're litigating, but also where might you have the best option of having a settlement? And most likely it will be a global settlement. And I guess I'm really glad to be on this panel because I think it's a really important question about U.S. patent leadership and litigation. Why do we care about this? Well, people are litigating global disputes outside of the U.S. that are effectively, at the end of the day, litigating U.S. patents, U.S. royalties on U.S. patents for U.S. companies. And how do we feel about that? In my mind, that gives me a lot of pause that a court in China or Germany or the UPC is deciding what the compensation will be for U.S. patent rights, for U.S. patent holders.
So lastly, I'll just add, from a very sort of a practical viewpoint, I assume probably lots of lawyers who advise clients undertaking strategic enforcement initiatives, where to file their suits, give the same advice that I do, which is file in the UPC for the reasons that Courtney gave and the reasons that Phil gave. But to be, even more pointed, you can get a real injunction in the UPC, and you usually can't in the U.S. It's a lot less expensive in the UPC. It goes a lot faster in the UPC. The judges are really good in the UPC. They have modern rules in the UPC. You go right down the list, every single category, it favors the UPC.
Yeah, and I was just thinking for everyone in the room who doesn't see the prices, maybe it makes sense. And please correct me on the timing, and the prices, but in the U.S., a patent litigation case is going to cost somewhere between $10 and $20 million. In the UPC or in Germany, it's probably 2 to 3. In the U.S., we have an investment in a video case the case was filed in 2019, and it might go to trial this year. That's absurd. And that probably cost the company over $20 million. So these are really easy, objective pieces of data. And at the end of the day, what are you going to get? Just to keep it going, we might get a trial in 2026, which means it will go up on appeal. It might be remanded. Maybe we'll get a final non-appealable judgment in 2028, 2029. That's 10 years and over $20 million. So why would someone ever come to the U.S. if they could get it elsewhere?
So thank you, Courtney. You just reminded me, your point about the federal circuit, there will be an appeal to the federal circuit. The more successful you are at the district court, the more likely it is the federal circuit will reverse, remand, cut damages down very substantially. So it's like there's no point in any of this.
Yeah. And one other, I'm commentary, like the civility, the encouragement for professionalism and civility, especially on the standard essential in Europe, is so much stronger than here, right? The rules really force the parties into a FRAND licensing discussion early, and they penalize the delaying, bad acting of a party that doesn't want to participate in the FRAND discussion. And we have sort of, to my knowledge, really no such encouragement or incentives built into the U.S. system here.
We brought up the Federal Circuit, which is near and dear to my heart. I clerked there. I've represented folks in a lot of cases in that court. But one thing I will say is almost never these days do I see a settlement driven by a district court decision while it's pending appeal, because the reversal rate has been so high, particularly for significant judgments, that there's very little incentive for a defendant to settle. And to the point that was already made, I mean, there was a study that just came out last year that basically said, more or less, if you have a judgment over $100 million, good luck at the Federal Circuit. If it's over $500 million, you're really, it's zero, exactly. And it's not that there haven't been these judgments. There have been multi-billion-dollar judgments that have, for whatever reason, not withstood the Federal Circuit. So going back to the point about timing, the Federal Circuit also, unfortunately, has had an increasing delay between the filing of an appeal and the disposition. And the latest numbers from the court show district court appeals for last fiscal year at around 20 months, PTAB appeals around 21 months. So until recently, you almost always have IPRs hand in hand with district court litigation. And assume the district court action has stayed, you have your IPR, there's going to be a Federal Circuit appeal. You're going to come back, you're going to get to judgment, there's going to be a Federal Circuit appeal. If you look at just the two Federal Circuit appeals, and that's assuming there aren't remands and additional appeals, which does happen, you're talking almost 4 years just of the appeals, let alone all of the district court litigation, the PTAB litigation, and it's just a tremendously long time.
Kristen, I don't know if this is now overrunning the question, but if you draw out what happens when you lose relevancy, that's really what we're talking about, and it's happened, right? When you lose relevancy, then you lose the muscle memory and you lose the ability to manage these kinds of issues. The quality of the courts degrade, the quality of the advocates degrade. Parties just don't even think of the U.S., whether they're in the U.S. or outside, and the whole system moves elsewhere. We've seen that in other countries where you want to bring a dispute of any kind, and you find out, well, there's no one who can represent you. The courts don't know what you're talking about, and so you wind up moving elsewhere. Same thing now is happening in the U.S. with our ability to handle patent-related disputes, particularly the complex ones we're talking about here.
Well, that's a nice segue, Dave. So I really don't know why I'm up here, because they could run the panel without me. So for all the reasons that we just heard, litigation is moving elsewhere, and that has consequences, as Dave just laid out, but possibly more consequences than just loss of muscle memory, and our quality is degrading. But now we're kind of turning over IP policy leadership to other countries. So my question is, we've long thought the United States was a leader in developing IP policy, in part, but not only, because courts were very active participants in the IP ecosystem. As we see cases moving to these other jurisdictions, are these countries now, the countries duly named and others, are they taking leadership of IP policy issues? And what does that mean for our national success, for U.S. innovation, and for U.S. innovators?
I'll dive in. So I think the lawyers on the panel have indicated, why litigation is moving outside the U.S. And have, I think, cast it somewhat, not positively, but suggesting that there are benefits to moving litigation outside of the U.S. And I think I also want to highlight that there's some costs to that, separate apart from what Dave mentioned about how does that impact access to justice in the U.S., but it's not all rosy outside of the U.S. either. So, I had mentioned that in the UK and China, which have become very popular jurisdictions for infringers to bring cases. They've been using tools like anti-suit injunctions and interim licenses to enable their courts to take jurisdiction over cases and set global rates, oftentimes without consent of the patent owner in the dispute. I mentioned Brazil is a very popular jurisdiction because they have been inundated with cases there. They're actually slowing down a bit and are maybe skeptical that all of these cases, in fact, have merit, and are, starting to appoint experts earlier on to help them. I would say there are some questions about the actual expertise of some of the experts, particularly in SEP cases that can be problematic. And so when we see this litigation moving outside of the U.S., because of all the reasons we've mentioned, it's not all positive, right? Because these developments that I mentioned, particularly in the case of standard essential patents, but this is true of all patents, right? Weakens our ability to reliably enforce our rights, which undercuts the ability of U.S. companies to maintain technological leadership. Because if we can't afford those rights or can't enforce those rights, then we can't fund the R&D that allows the U.S. to maintain leadership. Despite on the first panel talking about the importance of government investment in R&D, right? Our economy is really largely relies on the R&D investment of private companies to sustain innovation. So I'll stop there.
No other thoughts on U.S. leadership in litigation?
No, I think Julie just summed it up really well.
Okay, well, now we're done.
I don't think anything's perfect. I agree. I think there are problems in a lot of these, but it's all tied together. We just listened through a panel that was, I thought, really important about how important these rights are. But if they're not enforceable, they're not anything. I mean, by definition, a patent is a right to exclude. So if you can't exclude, it's not worth anything. And then you go right back to the hour plus we just listened to, that I think everyone up here probably very much agrees with. So patent litigation seems to be a dirty word, but the reality is that is the right that a patent confers, and it is a right that is more and more important for the little guy than for the big guy. It's funny, there was a statement earlier of patents are only important for the big guys. I would actually say the opposite. I think once you're a big guy, you don't care about patents anymore. You have maybe outside of the pharma worlds.
I might disagree.
You're so big. Well, you guys are a little different too, but a lot of companies are, especially consumer-focused companies, are really about market power at that point. And so once you have the market power, you don't care if you have the patents anymore. And so it's the little guy in the next generation that needs these to sort of be the next big innovator. And I don't think it's the big guys that make most of the innovations. It's not the incumbents. It's the next guy in his garage and the next PhD coming out of university. And we need to give them the right protections. And I am generalizing. I agree with it.
Yeah, I mean, I think it could bring a little nuance. I think a little bit what you're aiming at is, some companies which are vertically integrated do not need to rely on patents to monetize their innovation, right? Whereas one great benefit of strong patent rights is that you don't have to be vertically integrated to engage in the innovation ecosystem, right? Having not being able to enforce those rights impacts who engages in innovation, right? I think it's important to think a little bit about. I think Mark was bringing this in the first panel, but sort of the geopolitical dynamics around technology leadership, if the U.S. is not a leader in IP policy, that's going to have a profound impact on U.S. companies. So companies like Qualcomm self-fund our R&D, right? And our ability to do that depends on the strength of the patent system. But at the same time, right, we compete with companies that don't have these same market pressures. And so it's really important to have U.S. leadership and IP policy to drive innovation and drive this sort of bottom-up model of investment, particularly that Courtney was pointing to.
So just returning to your question for a moment, are other countries stepping up? Well, they certainly are, as the other panelists have mentioned. But the whole set of implications of that reminds me of an adage that my father used to use: do unto others before they do unto you. I'm sure we've all heard that before. And so in that world where we've ceded not only control, but even input, effect, leadership, we should expect that the countries that are now exerting leadership, the UK for its part, the EU and particularly the German courts and the UPC for their part, are going to do not what's in our best interest, but what's in their best interest. And that point extends to China, of course, equally as well, if not more so. So, we shouldn't be surprised then at what's happening. The UK courts are handing out these interim licenses like Pez candy. As crazy as that is, the UPC, my own humble opinion, is doing a much, much better job. But at the end of the day, they're at war with the commission, which is putting out one crazy proposal after another, the most recent one being the new LNG license negotiation group guidelines, which is to say buyer's cartel, endorsed by antitrust authorities, again, as crazy as that sounds. And so we already are, and we're going to be living in a world where we're not setting the rules here, and we're going to be continually fighting a defensive set of battles and a war on our back foot, with others setting the rules and us having to react to them. That's the implication of losing leadership.
I was just going to say, for a long time, the United States, I think, was viewed as the gold standard for having predictable and robust intellectual property protections and having efficient and effective remedies, enforcement mechanisms. And we exported that throughout the world as a key point in free trade agreements, is that we would want other countries to similarly respect intellectual property rights and make them effective and predictable. And there's been a slippage there, and I think the TRIPS waiver was a huge example of that, where we have the United States actually leading a conversation about waiving intellectual property rights at a time where they were arguably of critical importance, and enabled such a rapid response to the pandemic. But without being that gold standard, I think it's harder for the United States to preach to the rest of the world that you should follow our system. And the world's going to be looking, as my other panelists have said, to those who are stepping up and taking over that role. And we cede our policy influence.
So Phil, I'll take that. That's a great point, and I'll take it at like a half step further. The U.S., of course, just recently finished the annual Special 301 USTR program. I was half expecting and half wishing that USTR would put the U.S. on the Special 301 priority watch list because of how badly our system is screwed up.
I was going to ask about that without putting anyone's name on I heard during our prep call that we should have put ourselves, but if Dave's gonna go ahead and say it, I'm gonna let him say it. So we also have some suggestions for solutions and who should fix it. But before we get there, I want to ask a few other questions about how we got to this place from some of the things that came up during our prep call. And I'm gonna start with Phil. You were talking about the federal circuit and how there's very little settlements there, but I believe at least some of the people during our prep call talked about how the federal circuit isn't even patent experts anymore. And that may have some implications for our leadership, as well as receiving very little deference. So do you want to take either of those topics on?
Well, I guess, I don't know about the being patent specialists. I don't know if that's absolutely necessary. I may differ from some of my panelists on that. We at my firm, we do a lot of patent litigation in district courts with district court judges who are not patent specialists and juries who definitely are not patent specialists. But I do think there is a problem on the second point, so the deference point. I would say, for whatever reason, and I'm not saying it's intentional or conscious, but there seems to be a lack of deference to fact finders, to district courts. And I do wonder if it would help on the composition of the court if we had more former trial level adjudicators. You know, we had Judge O'Malley for a while, now we have Judge Stark. Maybe we should have more district court judges or people who are judges in other tribunals at the trial level at the court, because I do wonder whether appellate judges sometimes realize the real world implications of cases bouncing back and forth. And we see this a lot. You'll have a trial and it goes up, and then it comes back down on the liability issue, and it goes back up on a damages issue, and then maybe even back and forth again. It's just years and years. And what does this mean for the parties? So I think, I'll just leave it there.
I can't comment on the judges of the federal circuit as a non-lawyer, but just maybe to speak to the point that's been raised just now, but earlier also about the length of disputes. I mean, particularly in SEP matters, there's usually very little dispute about the need to take a license, particularly given the size of the portfolios that are under discussion. And it's really just about what's the appropriate rate. And so to have a dispute drag on 10 years without resolution, where everybody's more or less in agreement that something is owed and it's just a disagreement about how much, seems to be a particularly ineffective system.
Yeah, I'd like to touch on both. I definitely comment that I think Fed Circuit's moving away from patents. I don't necessarily think they need to be patent experts, but we had more engineers, and sort of maybe it was just this, it felt 20 years ago like there were more judges that believed in the patent system, and now it feels fairly hostile. And maybe that's combined with this lack of deference, even on issues on appeal where it's pretty clear what the standard of review is. They might call out the correct standard of review, but I don't see it applied necessarily. And that's where you're right. Like, just having more trial judges come up that understand what already happened and how thoughtful the judges and the clerks and the jury all were on their respective decisions, mostly the jury at that point, right? When you're taking a verdict up on appeal. But I'd also go to the district court. I would love, I don't know the numbers, I would love if someone has them to compare. Obviously, you have to take the criminal docket off, but to compare in civil matters what the timeline to adjudication is on a patent versus a non-patent related matter. I mean, judges have a lot of discretion over their calendars, but I can't believe some of the federal, the non-patent federal cases take as long as the federal cases do. And my personal guess is that judges don't really like patent cases, and so they just push them off for longer in a lot of jurisdictions, not all. But they take a really long time, and maybe that's not a patent thing. Maybe that's an every issue thing. But that's a real problem for the trial systems across the board. If it takes years and years for any plaintiff to really get remedy. I mean, the everyday person just does not have the funding to do that. And it's a reality that if the system's out of reach because of expense or time or both, then it doesn't exist at all, to the justice delayed, justice denied comment.
Can I ask a question? Because you're kind of the perfect litmus test for what happens when the federal circuit becomes problematic, as I think we're all agreeing has occurred. For, when you're engaged in lots of litigation and trying to figure out, either how to avoid it in some cases, or how to minimize it, or how to manage it. What is it doing to your decision-making process to have to manage federal circuit process the way you now do?
Yeah. So for those of you who don't know what Fortress does, a large part of our fund's business, we're basically a private equity fund, and we invest in standalone entities that are in the midst of litigation or licensing, right? And they're public and private universities. There are lots of private inventors. So David's question is that I probably see 30, there are 30 investments at any time that are going through this process. And the real answer is, well, we're looking in most cases, and there are actually market exceptions to this, but we are looking for portfolios that have patents outside the U.S. It circles all the way back to the original question. We are very reticent to invest in a entity that wants to bring cases that are based only on U.S. patents, because the time to resolution is just far too long, and our investors don't have that appetite, both on time. And I guess the other thing that Phil brought up, and then we haven't really circled back to, the reality that for really fundamental innovations in many industries, the real remedy number is high enough that the Fed Circuit, even if everything should be going through, the Fed Circuit will flip it. I mean, the Berkeley Law study statistics are pretty clear that if you're over $100 million in a jury verdict, you have a 42% chance of getting reversed. And if you're over 500, the answer is it's 100% chance you're getting reversed. And so from an investor perspective, if you're paying $20 to $60 million in litigation fees, and over 100 million really has a very low chance of surviving, that's a hard place to be. You can go to Germany or the UPC and get a remedy faster and less expensive and frankly more predictably.
So that's stunning. And Courtney, I just want to put a fine point on something you said, which is like diametrically opposite from 20 years ago. 20 years ago, I mean, you tell me if I've got this wrong, but my interactions with litigation funding 20 years ago would have been, the funders would have said, we really couldn't care less what patents you have outside the U.S. We just want to know about the U.S. patents. Now it's opposite.
Yeah, absolutely. And the other I should have said is we want to see open applications, because to the extent you're in the U.S., with the IPR world that it was what it was until a year ago, we needed to know there was flexibility there as well.
And maybe to just connect all the dots, right? So if you're not able to get litigation funding, then if you're a small entity, I'm guessing it's going to be harder for you to defend against infringement. If you can't enforce your patent, then you can't fund continuing innovation, right? To kind of sort of bring it back full circle to where we started, right?
Yeah, so we do a little bit of litigation funding, but most of what we do is really it's private equity investment, just to be clear. But Julie's point.
Apologies.
But no. But it's true for both. I just wanted to avoid but it's true for both. We partner with a lot of inventors and universities in particular. This is true for, that come to us and say, our role is innovating. Our role is R&D. We don't know how to license, and we don't frankly want to divert our resources to engage in litigation and licensing. And that's why we're coming to you. One, because we don't want to pay for it, but two, because it's not our expertise. And we want to keep focusing on our R&D, but we can't do that unless we feel like we can partner with someone that can help do the rest. And the someone who can help do the rest isn't going to do it if it's not worth it. Back to the market, the market forces from earlier. I mean, this doesn't work if there's no market that supports it.
And I just wanted to pick up, because it was mentioned, another one of my favorite topics, which is the PTAB, IPRs, the current, just briefly. So, I mean, what's happening right now, if you're a patent owner, things are looking pretty good at the patent office right now. Not a lot of IPRs are being instituted, and there's this NPRM pending that's very favorable to patent owners. And I guess I applaud the office for doing rulemaking. So, perhaps there's a little bit more sense of permanence, because it is very hard to get Congress to legislate right now. But being a litigator, I have to say, even at my firm, we've had multiple cases where you're already facing the gauntlet of getting through district court litigation, the inevitable IPRs, sometimes multiple rounds of IPRs, including from supposed third parties that are at least artificially disconnected from the litigants in the case. But then you have this possibility of an administrative agency effectively nullifying a jury verdict. And we have seen this, and others have, and I'm sure everyone in the room has seen this, where you can have a jury come to a conclusion that a patent is both infringed, often to the tune of hundreds of millions of dollars, and also determine that the patent is not invalid. It withstands a validity challenge in Article 3 court. And then after that, the PTAB comes in and says, no, those same claims are not valid. And because of Fresenius and because of the way that the timing works out at the federal circuit, that's effectively what happens, that the jury verdict will not matter. And there have been cases where the federal circuit will decide the PTAB appeal first, and then you get to the district court appeal, and it's moot.
I'm not in the business typically of arguing Amazon's points for them, but I would commend to you this IAM article from yesterday. I think it's worth noting that the uncertainty that this creates benefits nobody, right? Like even the alleged infringers are not happy with this uncertainty where we have kind of this change in policy from administration to administration. And so I do think the rulemaking is one step in the right direction in terms of providing more certainty. Obviously, some legislative fix would be even better. But I think that is the one thing, or that one of the things that that this former policy person at Amazon highlighted was as one of the things that's driving them to litigate outside of the U.S. is this level of uncertainty around IP policy in the U.S.
So I think some of this brought up a comment that I have in my notes here about the big swings that come with each administration coming into office and big changes. Obviously, that's most noticeable in the patent office, but does what's happened in the patent office affect certainty in the courts? Is that going to drive our litigation leadership one direction or the other if we get a little more stability within the patent office at any time? They're all stumped because I didn't promise to ask this question.
I'll start on that one. So, Kristen, if I understand the question right, I would say that lack of stability in the USPTO, to start it out this way, definitely is not helpful in the courts. Mm-hmm. So take Section 101 as an example. That is one area that has swung fairly wildly from one administration to the next. The Patent Office's approach to examining and rejecting or granting patent applications under Section 101. When a new director comes in and puts in place new examination guidelines, examiners react to that, and it creates chaos. Not in the PTO, because examiners react to it and they do whatever they're told. It creates chaos in the applicant community trying to figure out how to navigate from administration to administration. But stepping back, it creates chaos in the system more generally, because then people like me are asked to advise clients once these patents issue, or on patents that were issued during administrations that are being lenient on examination under Section 101. And our reaction to clients is, don't count on this patent despite the fact that it was issued being worth very much in an enforcement scenario, because the courts, particularly the federal circuit, are not aligned with the PTO, and the PTO's approach is necessarily not aligned with all the law because the law is so cross-cutting. So having a fundamental agency that is shifting its policy from administration to administration in radical ways, I would tell you, is not good for the system, and it's not good for the relationship between the agency and the courts either.
Great. Nobody else wants to tackle my question that was a surprise.
I mean, I think there's some influence on the courts. I think that, to me, the bigger problem is just the perception of the integrity of the system with things that are swinging so wildly. But also the sense that someone who's not paying too much attention might think that this is a partisan issue. And I think that is really unfortunate. I've sensed over the last several years certain efforts to make certain intellectual property issues line up with one party or the other. And one thing I really enjoy about intellectual property, and I enjoyed it when I was on the Hill, is that it's this nice bipartisan island of kumbaya moments, and certainly lots of disagreements on industry lines because different stakeholders are affected differently, but not in a partisan way. And I think it will be really unfortunate for our intellectual property systems if we get to a point where people associate strong and predictable intellectual property rights with one political party.
Okay, I'm going to throw a question to Julie, I think. I have a note here. And you've touched on it, but I thought maybe you could add a little more detail to it. FRAND experts that aren't actually experts. And so how does that affect litigation leadership?
I can say something about that. Interesting things afoot in Brazil, I will say this. So currently the state court in Rio has something like 40 SCP cases before it, or maybe 40 patent cases. I want to hedge there because I don't know if they're all SCP cases. But they're starting to become a little skeptical that all of these cases have merit. And so my understanding is that historically the practice in Brazil was to pretty quickly grant a preliminary injunction and then appoint a technical expert to help the judge, decide the issues of infringement and validity before moving to the permanent injunction. But because of this increased volume of cases, now that appointment of experts is happening before the preliminary injunction, which is fine. The judge wants more information before ruling. I don't see anything particularly problematic about that apart from it slowing things down potentially. But we recently saw a case in which the judge has appointed, and I'm going to use my air quotes here, a FRAND expert, which again, on its face is not particularly problematic. They've appointed somebody to decide whether or not the licensor's offer in this particular SCP case was in fact consistent with FRAND. I would say that I would encourage the courts also to consider whether or not the licensee's conduct, or the potential licensee's conduct was consistent with someone who's willing to, in fact, take a license. But in this particular case, I think the expert who was appointed has their expertise in the real estate industry, which is property, which is a good start. But I'm guessing the nuances of assessing value there are probably slightly different than in the patent space. So I think, and I think it just goes to the point that I mentioned earlier, right? That yes, patent owners are going outside the U.S. Because of their inability, either for timing reasons or inability to get the relief that they need in the U.S., but it's not all positive, right? Some of these jurisdictions, setting aside the UPC in Germany, for example, not all of these jurisdictions are well experienced, particularly in the case of SEPs, right? They might be fine in sort of general patent disputes, but there's a lot of nuances in SEP cases, and yeah, so I think that, we'd want to encourage these jurisdictions that are going to be seeing, more and more of these cases until the U.S. gets its house in order, to be thoughtful in these decisions. But that's hard to do, right, when we're not sort of doing the work ourselves.
Right. Julie, can I ask a question? I'm sorry if I just missed this, but so the Brazilian court appointed an expert. So this was a court-appointed expert, not like dueling experts hired by the parties, right?
Yeah, so again, I will disclose I am not a lawyer, and I am even less familiar with how cases proceed in Brazil than they do in the U.S. But my understanding, unlike the U.S., In Brazil, there's a court-appointed expert to provide technical expertise to the judge. I don't know whether or not the parties themselves have their own technical experts. I would defer to the lawyers who may be more familiar with that, but I do know that the judge appoints a technical expert to advise them, since obviously they're not experts on the subject matter of the patents.
So just as a comment, setting aside that this expert sounds like their expertise had nothing to do with intellectual property or patents, setting that aside, the prospect of judges appointing technical experts to advise them, but appointed by the judges, is common. You see that in lots of other countries, in Asia, in Europe, and I don't have a particular problem with that. But I certainly take the point that if you're going to appoint an expert, particularly in a well-developed country like Brazil, you'd think you could find an expert in the technology involved and an expert in the patent system.
I should be clear, there was 2 experts appointed in this case. One is the technical expert, so to just help with the issues of infringement. And then there was a second expert appointed to assess the fairness of the licensor's offer, just in case that wasn't clear.
Okay, I'm going to ask one more unscripted question, which is possibly dangerous because it doesn't come from my notes, but actually comes a little bit from something Courtney said. And then it is good news. After that, we're going to move back to a scripted question and maybe get some positive thoughts about how we might fix this problem. But just as a last random question, we've been working from the assumption that we are losing leadership because we are no longer pushing strong IP rights out into the world. And so that's a negative. Is it possible, do you have any sense of whether we're pushing hostile IP thoughts out into the world instead? Are we swinging from very strong IP rights come from the U.S. to the U.S. hates? Is that what's heading out there?
I would say yes. I think you have to look no further than Europe, where the European Commission recently released a study on their IP enforcement directive. That's a little bit in the weeds for folks, right? But obviously patents are national, and so you can't have patent law at the EU level, but they do have this IP enforcement directive, which is sort of the EU's view on how member states ought to enforce patent rights in their individual jurisdictions. And one of the key, and so it's been a while since the Commission has reviewed this directive, and so they've taken it up and commissioned this report. And one of the recommendations of the report is that EU countries import some version of eBay into European patent enforcement. So definitely yes. I think as much as we would like strong patent enforcement being exported around the world, I think some of our missteps, and I view eBay as one of them, are being exported as well, or at least attempting to do so.
Yeah, I think there are a lot of collateral attacks right now on people in the U.S. that need to bring litigation. They are not outwardly saying don't bring litigation. They are doing everything but. So in the big beautiful bill, Senator Tillis proposed a 40% tax on all patent litigation funding, or all litigation funding, period. It wasn't patent litigation. That would basically shut down the industry. It was backed by insurance companies and big tech, and so ostensibly it was on tort reform, but really it was against all litigation and litigation funding. Kristen, you mentioned the Delaware Connolly's order on lit funding, but there's another order that requires, only for Judge Connolly, that requires disclosure of all investors and shareholders in a company if it's a non-public company. So by requiring disclosure of every single equity holder or other holder, you're basically, unless you're a public company, thank you, big tech, you are in a position where you have to disclose all of your investors. And whether it's intended or not, the way that's written is that you need to disclose every single individual. And when I say this, people say that can't possibly be true, but read the rule. That's what the rule says. So when I have a pension fund from the university system in Texas, or California teachers or firefighters, I'm supposed to disclose every single policeman or firefighter or teacher under the rule, under the language of the rule. There's a Darrell Issa proposed legislation that never gets out of committee, but yet keeps coming back, that's requiring the same disclosure of all investors, either in litigation funding or on the equity side. And you have a Klein bill that did come out of committee that's requiring disclosure of all foreign investors. And while these are all ostensibly here to say we want transparency, the reality is that's not what it is. It's super one-sided. They're looking for, the name of all of these investors, which is prohibitive. And we all know from the investment world, that means investors simply won't invest. A disclosure on the agreement side means that the defendants get to see what the budget is for the plaintiffs, but the plaintiffs don't see what the budget is for the defendants. So I think there are a lot of collateral attacks under this guise of either transparency or stopping big bad China or others from, allegedly using litigation for some espionage focus, which I've yet to see any evidence of, that are really just showing hostility to enforcement of patent rights. And it goes back to my comment of sort of enforcement and litigation is a dirty word, but without it, I don't really know what property right exists for patents.
Yeah, and Chris, I think it's a great question. I think the U.S. Has intentionally and unintentionally exported weaker intellectual property rights. And I think one reason is because we historically had been the gold standard, people do look to us. And when they see things like what the Supreme Court did with patent eligibility, what the government is considering with Bayh-Dole, or any of these other topics, injunctive relief, people take note. But what I mentioned before, the TRIPS waiver, I think that was just such a watershed moment where you had the United States and the USTR actively advocating for waiving intellectual property rights. And I think some folks really thought that was a moral victory, but I have yet to see any evidence that the TRIPS waiver resulted in any significant increase in access to vaccines or other products that were important for the pandemic. But I think it sent an incredibly powerful signal to the rest of the world about the U.S. and how it views intellectual property rights. I think it's really unfortunate.
Okay, well, maybe we can offer some hope or at least instructions. We've talked about the scope of the problem. We seem to agree that the United States is losing its voice as leadership, losing its voice as a leader in IP policy. But my question now is, what are the most important steps that the U.S. should take to regain leadership, and who, importantly, has to make that move? Can the courts do it? Does it have to be Congress or somebody else altogether? So have at it, guys.
Yeah, I'll get a start on that one. I would say, in the category of location, first up should be injunctive relief, and the court could fix that. It created the problem in the first place with eBay. Supreme Court could fix it, but we've got a great piece of legislation, the Restore Act, and with a little bit of luck and some administration support, that one could be fixed by Congress, and that alone would do wonders to restore the balance in the U.S. IP system. I'll give you just the other two pieces of major legislation real quick, and then let others offer their comments. I would say that the PIRA legislation, I think Phil mentioned before, Patent Eligibility Restoration Act, is another place where, sure, the courts could act. They created the mess in the first place, but they don't seem to have any appetite to act. But Congress can fix that as well with legislation that's pending. That would do a lot to reset the U.S. agenda on eligibility and send a positive message and a stabilizing one. And then lastly, there was the Prevail Act, which would, in an appropriate way, fix the issues with Patent Trial and Appeal Board and get us out of this swinging pendulum problem with every successive administration reversing what the previous one did with respect to the operation of the PTAB. So sure, well, on that last one, the courts really can't act. It's got to be Congress. But for the other two, it could be the courts. But Congress at this point is the better solution.
I would second everything Dave said. I would maybe also add to that, I think the administration, particularly the PTO, USTR, Antitrust Division at DOJ, should be engaging with their international counterparts to help ensure that some of these judicial practices and regulatory proposals that we're seeing outside of the U.S. don't impede robust and reliable enforcement of patent rights. I think we've seen the current administration be really engaged in the U.S. on ensuring the strong enforcement of patent rights. I think it would also be helpful to have them look outward and if they want to support U.S. companies and have U.S. companies continue to maintain innovation leadership, then they also need to be focused on some of the problematic developments outside of the U.S. as well.
Well, I agree with all that. And certainly, Dave, with your point, I think making injunctive relief more accessible would be the single most transformative thing we could do in the patent litigation space. It makes for such a different dynamic and can bring people to the settlement table in places where it really should make sense, but it doesn't in the current environment. In terms of who should do it, I think Congress, I agree with that as well, is the ideal. That's the ideal place. It is really hard right now to get anything through Congress. You have very deep pockets on all sides. And I earlier was saying I'm glad it's not a partisan issue, but the downside of having a bipartisan issue is no one's going to ramrod it through when they're in power. So you really have to do a lot of work to bring people together. I will say, I think we should note on the panel for rights holders, there have been some very positive things in the current administration. I think the NPRM is one of those. It really could go a long way to reducing duplicative litigation. And also, we were talking about the federal circuit. Tremendous part of the federal circuit docket now are appeals from IPRs. And I think the federal circuit judges themselves would love to see a reduction in that, but I would have to think that would bring the pendency down on appeals, which would also help. And the other thing, I don't think it's come up, but surprisingly to a lot of folks, DOJ Antitrust and the USPTO jointly submitted briefs in an ITC case and in a district court case. I know at least one of those was completely unprompted, stepping in the district court case saying, from our perspective, there's no bright line rule that says SEP owners should not be able to get an injunction in an appropriate circumstance. And I think that's the kind of influence and signaling that is really important.
Also, they should keep citing me in those briefs. But anyway, I'm sorry to interrupt. Courtney, go ahead.
No, agree with all of it. I just also wanted to second, I think it was Mark, but it could have been Steve that said it in the last panel, is just, it would be really lovely to have the administration senior leadership talk about how important patents in particular are to innovation and to really call it out. And it doesn't, setting aside politics, I think everyone thought Donald Trump made so much money off his name, maybe he'll have more respect for property rights. But we haven't seen that really. And it would be really nice to have senior leadership step up and say it out loud. Howard Lutnick made a lot of money off patents. It would be really wonderful for him to stand up and say it out loud. We haven't seen enough of that. It would maybe even help some of these legislations, and I hands down and behind all of these legislations, but absolutely the injunctive relief restoration in particular.
So we are at the point where I'm supposed to open it for questions. I will keep asking unscripted questions of them, but I'd love to hear from the audience, and I'm sure the panel would also love to hear from the audience if y'all have questions. Yeah, go ahead.
So, Courtney, you mentioned the possibility that exists overseas in general and in the UPC. Can you elaborate a little bit more on that, and what, if anything, should be done to, bring that back to the United States and our courts and stuff?
Yeah, I mean, I wish I knew the answer to the second part of that question, but maybe having judges participate in more of these international conversations and more conferences like this where everyone sort of shares what has happened and what the biggest sort of progress has been made in each of these. But even in the last couple of months, now I'm going to forget I think it was the UPC, but it might just have been Germany. There was a voice HMD decision where on standard essential patents, where Voice Age had done everything they were supposed to do in the dance, written a letter first, had meetings first. HMD just said, no, don't want to even talk to you. HMD gave a counteroffer. The counteroffer was very, very low. And by the way, at this point, I think there had been many licenses done. It wasn't a question of what really the FRAND rate or at least rate range would be. And the court said enough. You don't get to counter with some unacceptably and unsupported low number and only post a bond on that number. You have to post a bond that's within reason or engage in a really good faith back and forth. And the idea of not responding to emails or phone calls and just saying it's a counteroffer when really it's not within a reasonable range was unacceptable. And the court just said, this was the appellate level, it's not enough. You weren't acting FRAND. That pushes it right back to the patent owner's rate, and that's what was appropriate. And that then drove discussions, right? But it had to go all the way to there. But that sort of, at least the courts there have said, you have to engage. I need to see you respond. I need to see you respond reasonably. And then you can have a good faith negotiation. And I don't think anything like that exists in this country. Oh, do I have yours? Sorry.
We had to share one with the audience.
This really wasn't the question, but since you brought up the HMD case, I think it's a good opportunity to point out how some of our overseas regulators aren't particularly helpful in this space. So in that case, the European Commission filed an amicus, which basically said, I'm sorry, you need to do the Huawei ZTE steps in the exact order. Otherwise, or evaluate them in the exact order. Otherwise, you're doing it wrong. And I think the German court's response to that advice was like, I think we know how to decide our own cases. Thank you very much.
This also, the point Courtney's making is, in my mind, an example of what, those of us who spent some time in Florida now, and a state in which it's legal to carry firearms, and many people do, there's a saying here that when you're not sure if the person you're interacting with has a loaded weapon, you tend to conduct your interactions much more respectfully. And I think, right, the point is when there's an injunction in the background and there's some clear rules that have come about, like in Germany and under the UPC, parties know how they need to behave. They know that if they misbehave, and this is both the patentees and the implementers, they know that if they misbehave, there could be some strong consequences. That leads to civility, and it is a good thing, as Courtney points out.
Other question? Yes, many hands in the audience. Doug, go for it.
You spoke earlier about a lot of the difficulties with the U.S. patent litigation system, how slow it can be, lack of exclusion with the injunctions. I was a little surprised to not hear any of you reference the International Trade Commission, which will get you an order in 18 months, and it issues a thing that's quite nicely called an exclusion order. And I just was wondering about your view of the ITC as a part of all this process.
Yeah, so I actually was an ITC litigator, complainant side back at the beginning of my career. The problem with the ITC from our perspective is twofold. You have to have something you're enjoining that's coming in, that's an import. And you need to have domestic industry. And our perception is that, notwithstanding Lashify, domestic industry has actually gotten much more difficult when your domestic industry is linked to R&D of a licensee, because the licensee has to. It used to be 20 years ago when I was at the ITC that you could subpoena them and bring them in, and the perception now, and I will say it's my perception, but not just mine, is that if it's an unwilling DI, it's a willing licensee, but an unwilling DI, you're not going to get very far at the ITC. And so those two things are there. And then finally, the ITC, yes, even where it is available, it's still $15 to $20 million. It's still very, very expensive.
You just spend that money more quickly.
Yeah, exactly. You just spend it in 2 years instead of 6.
Quicker burn rate.
And I guess I would say it's not been a particularly helpful venue in SCP cases, right? Like, I think the one exclusion order that was granted there was ultimately overturned by the president.
So I'm not sure if this is entirely a fair question or sufficiently on topic. You described the transition as being largely bipartisan, both how we got to the mess and the proposed legislation to fix it. But Courtney, you mentioned a couple times that big tech was on one side of a lot of this. If you go back a few years, one of the major big tech companies' strategy before it had a major patent portfolio was to publish as much research as possible and basically scorch earth the ability of people to develop patents, because so much prior art, undifferentiated prior art, was in the marketplace. And so I'm wondering the extent to which a lot of this is kind of the oligopoly economy that we've developed, that, putting pharmaceuticals aside, a lot of the tech industries are fairly adverse to the copyright industries. They're fairly adverse to small inventors, and they're using market power as opposed to patents to maintain the status quo. And if that's the underlying driver for all of this, then where do we go?
I think that's true. I think you can pull up the public numbers on lobbying and what the big tech companies put into lobbying, and maybe they're 501c3s, maybe not, are putting into lobbying that are funded by big tech. And I think that's true. I don't know the answer to that. I mean, I think it's hard. Those are really important market players. I mean, I live on Amazon Prime to get through my day. So I think that it's really hard to herd the cats, which are all of the small inventors and the next innovators and the universities. And it's really easy for the large market players who have massive policy teams and lobbying funds to really to put their weight behind it. And so I think you need the bipartisan, the really pro-IP people on both sides. That ironically is kind of Senator Tillis. You've got Tom Massey. You've got some others that on both sides. Although the ones I'm trying to think of, that Kevin Kiley, these are kind of all the Republican side, but that are really Coons. Thank you, Coons on the Dem side. I was like struggling for one, but they you do have these players, and we have to really support both sides for those that are willing to stand up and sort of protect the IP rights.
And I would add to that, I think there are so many stories out there of these startups, potentially disruptive startups, who are approached by one of these large technology companies. And it seems like, what a great opportunity. And let's sign an NDA, and we want to learn about your product, show us all of your specs, your code. And then the next thing you know, it's stolen. And getting a response effectively of like, well, sue us. Like, we're bigger than you. We're going to outlast you. We'll buy you for pennies on the dollar, including your IP. But I think the point about the groundwork for this is there was a huge lobbying campaign, PR campaign around the time of the AIA, where there were billboards up about patent trolls. Like, no one knew what a patent troll was before that, but it's very effective branding that persists to this day. And I was talking with some people in this room last night about it wasn't just that. It was also planting the seeds for academic articles. And there's a lot of money funding academic research that tends to point in a very pro-infringer, if I may say, direction. But that is very influential both in litigation and in policymaking.
So this has been a great panel, and we've heard a really strong critique of many of the aspects of the current U.S. litigation system. I thought maybe I'd ask you all to pull back and look at a comparative perspective and compare what we still do right versus what other countries don't do so well, and maybe vice versa, who's doing things particularly well that you wish we would follow. And that it's obviously on dimensions like getting an injunction. But yeah, on the one hand, we have great access to evidence. On the other hand, that makes our litigation slower and more expensive, and other countries think our discovery system is insane. On the one hand, we have all the challenges cited, but on the other hand, we still have the rule of law. So you litigate, say, in China, and people often say it's inadvisable to litigate in an industry with respect to an industry that the Chinese government sees as strategic, that your case may just seem to be a little more difficult than it should be, and your opponent, your Chinese opponent may do better than you expect. So on these kind of dimensions, discovery, rule of law, accessibility of the courts, obviously we've talked about injunctions. So what are we doing right? What are others doing better?
Well, I'll go first, but I'll hit your first question. I think that we, notwithstanding the issues at the appellate level, at the Fed Circuit, we are the best country from a damages perspective. I think the damages law is pretty well developed. It's hard sometimes to comply with, but I do think there's there's been helpful decisions and some clarity on what is fair from a reasonable royalty standpoint and how to calculate it. I wish that could stand up, but I think it's expensive to comply and to do it well, but it lands in a pretty fair spot that you're looking at sort of, what is the benefit to the infringer? This is, of course, once you've established infringement, but what's the benefit to the infringer and how can it be assessed and calculated? And that really thoughtful process about what the benefit is something that other jurisdictions would benefit from adopting. The issue is more that I'm not sure when it goes up on appeal, anyone gives credence to all of the work that was done below. On the what do I think other people do better? I mean, look, patent infringement, strict liability. I don't know if I think evidence of infringement's really important. I think there's a lot of superfluous, and probably both sides would agree to this. On the one hand, maybe you don't need to hear about the inventor and his story and how he was a garage tinkerer, right? I mean, and on the other hand, maybe you don't need to know or hear about who's funding the litigation, because neither of those matter from purposes of the strict liability of patent infringement. So I think a streamlined process that cuts all of that out and just looks at is there infringement or not, like you see in Germany, is probably a much better way to go.
Yeah, I'll be quick. I mean, what can we do better? Injunctive relief, and as David pointed out, there's a bill out there, and it's one sentence, and it would fix it. So that's the Restore Act. But in terms of what we do well, I'd like to speak up for the jury system. I mean, this is fundamental to American law, and we trust juries with a lot of really complicated, difficult, and technical questions, and they are particularly good at doing things like assessing credibility, which really, is important in these cases. So I'm a big believer in that system. I think it's unfortunate that I've seen in recent years a pushback, especially from certain corners of the IP ecosystem, saying, no, we should just have technical specialists deciding all of these issues.
So, Mark, I'll go a little deeper here on something that I think is going well in the U.S. courts, in particular the Texas courts, and in particular Judge Gilstrap, on issues in the SEP area where other courts, the UK courts probably first and foremost, in addition to the Chinese courts, have been trying to set global royalty rates and get into these battles of anti-suit injunctions, anti-suit injunctions, now anti-interim license injunctions. I think the U.S. courts have done a better job at sort of exercising discretion, comedy, and staying out of that as much as they can, declaring, look, we're going to issue judgments on U.S. patents, infringement of those patents and validity of those patents in the U.S., but we're not going to get into granting global licenses or setting global rates. So I think that's an area where the U.S. courts in general have done a good job. And then the other one, bridging a little bit, is in the antitrust area. I think, again, coming back to this license negotiation group, LNG, which for those who aren't familiar, it's basically the German auto industry that wants to have the giant automakers, Daimler, Volkswagen Group, et cetera, work together, horizontal competitors, right, work together to depress SEP licensing rates coming in from SEP licensors. And in the U.S., we call that a buyer's cartel, and it's illegal, right? And to have the U.S. DOJ calling that out, which it has, is really good. And to have the Europeans in the form of the Commission, the antitrust, so-called antitrust watchdogs for Europe, not only sitting by and permitting these LNGs to form, but actually trying to endorse them is atrocious. And that's an area where I think the U.S. has done pretty well.
And we are now out of time. I hope you have enjoyed the panel as much as I enjoyed working with them. If you could give them all a round of applause, please.